Good day, students. In today's class, we'll see about acceptance. As we all know, acceptance occurs when an offeree agrees to be mutually bound to the terms of the contract by giving his consideration or something of value like money to seal the deal. Acceptance can be in express manner or implied. Express in the sense it can be either in words spoken or in written format. Also, it can be implied from the conduct of the parties. Next, who can accept the offer? In case if an offer is made to a person in specific, then only that person has to accept the offer and nobody else could substitute on behalf of that particular person. In case if offer is made to the world at large, then anybody who comes to know about the particular offer can accept it. Next, moving on to the legal rules of acceptance. First rule says that it must be absolute and unqualified, which means that the acceptance has to conform with all the terms of offer. Second rule is that it must be communicated to the offerer. So whatever is the acceptance from the side of the offeree, everything has to be communicated to the offerer. Otherwise, the offerer deserves right to withdraw the offer. The third rule says that it must be according to the mode prescribed. In case if the acceptance is not according to the mode prescribed, then the offerer reserves right to withdraw the offer. Fourth rule is that it must be given within a reasonable time. So in case if any time limit is specified, the acceptance must be given within that time. In case if no time limit is specified, it must be given within a reasonable time. Fifth rule says that it cannot precede an offer. If acceptance precedes an offer, it is not a valid acceptance. Sixth rule says that it must show an intention on the part of the acceptor to fulfill terms of promise. In case if no such intention is present, the acceptance is not at all valid. Seventh rule is that it must be given by the party or parties to whom the offer is made. So acceptance has to be made on the part of the offeree. Eighth rule says that it must be given before the offer lapses or it is withdrawn. So before the offer is withdrawn, the offeree must say his consent to the offerer. Ninth rule says that it cannot be implied from silence. So the acceptance of an offer cannot be implied from silence of the offeree or his failure to answer. Next, moving on to special terms in acceptance. First one is acceptance subject to contract. This means the word subject to contract in case if it is used in documents exchanged by the parties during contract negotiations. These words denote that the document is not an offer or acceptance, but negotiations are still going on. This term subject to contract is mainly used in property transactions and commercial contracts. Next is agreement to agree in future. If the parties have not agreed upon the terms of their contract but have made an agreement to agree in future, there is no contract at present. It is only they have made an agreement to agree in future which would take place at a future date. Now they are not entering into any contract. So this does not account to any acceptance on the part of the offeree. Next is acceptance by post. So the offeree can tell his acceptance by post. Contracts over telephone. Contracts can happen over telephonic conversation where the offerer can offer his product as well as the offeree can tell his acceptance over the telephonic conversation. Next, moving on to communication of acceptance. Acceptance may be communicated in an express manner or implied manner. Express in the sense it can be through words spoken or written. Either it can be through implied format, which is it can be seen from the conduct of the parties. Let me tell you an example. There are two parties, party A and party B, where party A is making an offer and party B is accepting the offer of party A. So party B is accepting A's proposal by a letter, and he is sending the letter of acceptance. Consider he is sending his letter of acceptance on 13th of this month. The letter reaches party A, that is the offerer, on 15th. So the communication of acceptance is complete when the letter is being posted by party B. Next, we'll see about time for revocation of acceptance. So an acceptance may be revoked at any time before the communication of acceptance is complete as against the acceptor. So the offeree can stop his acceptance before it reaches the offerer. So let me tell you an example. Consider there are two parties, party A and party B. Now A wants to sell his furniture to party B, and he writes a letter through post to party B that he wishes to sell his furniture. As well, now party B is telling his acceptance through post to party A that he is willing to buy those furniture. But what happened was party B's family is not okay with the second-hand furniture sold by party A, so they are convincing party B that kindly don't buy products from party A. So now immediately what this party B is doing is he is sending a fax to party A that he does not want to buy his products. Yes, now fax reaches party A before the post would reach him. So now party B has revoked the communication of acceptance before it is completed. And I hope you have a clear understanding about acceptance now. In case if you have any doubts, you can post it in the comment section. Thank you, students.